Okay, a very good afternoon to all our participants. Thank you so much for choosing to spend your Saturday afternoon by joining our webinar. To quickly introduce myself, I am Abang Iwawan, a construction lawyer from Lee Shamuddin Allen and Gladhill. I am also here in my capacity as the president of the Young Society of Construction Law Malaysia. Before we get to the topic at hand, let me just give you a quick introduction to the Young Society of Construction Law. Commonly known as YSCL, we are a youth-based society established earlier this year as a subset of the Society of Construction Law. Our aim is to enhance accessibility and empower the youth within the construction industry. We have a series of initiatives such as the #YSCL Youth Empowerment Series, where we invite guest speakers to share their success stories, insights on specific topics, as well as practical tips for young professionals and students. Another initiative we have is the #YSCL Cares, our community outreach initiative, where we aim to raise awareness and provide a platform for the youth and young professionals to collaborate with other public bodies and explore ways to curb current and important social issues nationwide. Now, today's webinar, Resolving Construction Disputes in the Time of COVID-19, is part of our YSCL Classroom series, which brings practical seminars targeted to new entrants to the construction industry. We will be splitting the webinar today into two sessions. The first session would be a virtual classroom setting, where our esteemed ADR experts will be giving you a quick introduction and practical guide to ADR within the construction industry, such as arbitration, mediation, and adjudication. The purpose of this session is to provide our viewers with a holistic view of ADR within the construction industry. We will end with a second session, which is a panel discussion on managing disputes in the time of COVID-19. Now, as the second session will be a discussion, I would encourage our audience to actively participate by keeping the chat box busy with questions and comments as we discuss along the way. Without further ado, I would like to introduce our first speaker, who would be giving a presentation on the topic of arbitration. Tan Swee Im is an international arbitrator member at 39 Essex Chambers. Her focus is on the construction, infrastructure, and energy sectors with extensive experience ranging from the early procurement strategy stage to contract drafting, advisory during the project life, through to dispute resolution. She is now a full-time arbitrator and adjudicator, as well as an accredited mediator. To name a few of her long list of accreditations, she is a panel arbitrator of AIAC, SIAC, HKIAC, and an advocate and solicitor of the High Court of Malaya, and a barrister at law of England and Wales. Swee Im, over to you.
Thank you very much, Iwawan, and thank you very much to everybody who's joining us this afternoon. As you say that this is actually a classroom series, so as a result of which we are actually going to be spending probably just about 10 minutes to explain about each of the ADR processes, or the main ones in any event. So as you said, that I am actually a construction lawyer for over 30 years, and now I sit only as arbitrator and adjudicator. And we're talking a lot about resolving construction disputes, and as you can see from my virtual background, I actually look out onto a big construction site. And COVID-19 is a scary time because there are 12 tower cranes, which are normally very noisy, which I get very irritated about, and it's quiet now. That's pretty scary when you're dealing with something in the construction industry. And as a dispute resolver, you know that there are disputes that are going to be oncoming. So very quickly about arbitration. Why is it that we are this afternoon talking about arbitration, mediation, and adjudication? That's because most construction contracts actually have references to all of these modes of ADR. And I am going to look at one as an example, and that's the AIAC, Standard Form of Building Contract, the 2019 edition. You can get it on AIAC's website. And if you just look at the index page, you will see that there are clauses that refer to arbitration, mediation, as well as a reference SIPA, which is adjudication. So let me just talk about arbitration. And for those of you who are already in arbitration, this would seem very, very basic, but I think what we're doing here is trying to address the new entrants to this area of law. So I'm not going to go on very much about it because just go and buy Thayananthan Baskaran's book. And if you don't want to buy it, just go to one of the libraries, the AIAC library, for example. If you don't find some books in the AIAC library, please come and look for me, because it's probably because I've borrowed them to my office on the second floor of AIAC building. In very, very simple terms, an arbitration is described, and I've lifted this from Thaya's book, is a process of resolving a dispute or grievance outside of a court system, but it still goes to a third party and an impartial third party. And in respect of that, both sides in the dispute must agree in advance to doing that. So in the case of arbitration, it's very important to understand that the forum for arbitration is derived a jurisdiction from the agreement by both parties. Very simply, no agreement to arbitrate, there's no such thing as arbitration. Now, for construction contracts, the reason why arbitration is talked about so much is because it is common to have an arbitration clause in a construction contract, as you have seen in my example of the AIAC standard form. But it is also very possible to have ad hoc agreements. So in the past, for example, when we have seen, particularly with the smaller subcontracts, there may be no arbitration clause. That is no hindrance to the parties coming to agreement to go to arbitration as and when the dispute arises. So all these are things that you need to understand, because unlike court, this is literally by agreement only. Of course, you have to look to the Arbitration Act, and for us in Malaysia, it's the Arbitration Act of 2005, which became effective in March 2006. We are, since 2005, a model law country. And when I say model law, it just means to say that there is cohesiveness between all the model law countries. Not exactly the same, but it's cohesive. The amendments that were enacted to our Arbitration Act in 2011 and particularly in 2018 are important, and you should just go have a look at those. Just make sure that when you look at the Act, it's not just the one without. Then, the other thing that I just wanted to point out to you also is that in our Arbitration Act, there is the opt-in and opt-out provisions. Part 3 applies to domestic arbitrations only. That's between two companies, two Malaysian companies. And it automatically applies to that unless you opt out. And the opposite happens if it's an international arbitration. One thing I wanted to say was that we have a lot of foreign contractors in Malaysia, mainland Chinese, Koreans, Germans, whatever. But bear in mind that most of these fellas are actually registered companies in Malaysia. So for example, you may have a Chinese mainland contractor, but very often they would register a local Malaysian Sdn Bhd company. And in that sense, the arbitration will then become a domestic arbitration. So these are all the sort of things that you do have to look out for. And it's not something that people will, you normally see in your textbooks, but it's just a practical tip. The deletion of Section 42 of the Arbitration Act arising from the 2018 amendments, that's an important point, but too much to go into today. Just go and read Thaya's book. It's in Chapter 9. Moving on very quickly, there are two main types of arbitrations that we have here in Malaysia. They're either the institutional ones or ad hoc. You will see from the slide here, I have put up 3 sample arbitration clauses. Now, if you look at the first one, clause 34, it speaks to agreement to refer disputes or differences to arbitration. And you can say, I can see, excuse me, in subclause A, any dispute, blah, 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 shall be settled by arbitration in accordance with our AIAC arbitration rules. Very clearly, they are going to be according to the AIAC arbitration rules, which means to say that it's going to be administered by the institution, in this case, the AIAC. So that's what we call an institutional arbitration. The next example you have there is also from a common construction contract that's often used in Malaysia, and that's the PAM, Pertubuhan Architect Malaysia. Again, you will see that it is in accordance with the current edition of the PAM arbitration rules. So that's also an institutional arbitration, except that the institution there is Pertubuhan Architect Malaysia. The last example that I have there is from a contract where I was the arbitrator, and this was a number of years ago, and it was from an old contract which you don't normally see today, but do actually check whether your arbitration clause has something like this. You can see that this is an extract. It requires such dispute or difference to be referred to a single arbitrator, and in default of agreement, appointed by the director of the Regional Centre for Arbitration, Kuala Lumpur. That's the old name for AIAC. You will note here that AIAC or KLRCA's role here is merely to appoint the arbitrator. It does not go on to say that the arbitration will be according to the AIAC rules. So in this context, you're actually dealing with an ad hoc arbitration. So in this case, I actually had to have a separate agreement with the parties where they appointed me, and the only thing that AIAC did was to do the appointment of the arbitrator, and that was it. So these are the sort of things that please do look out for. When you have a hearing for an arbitration, most of you are lawyers, and you would have been, at the minimum, called in the High Court, or you would have attended hearings, or in fact conducted hearings, and you know that the court actually is fairly intimidating and fairly formal type of setting. And you know, the KL High Court Construction Court is particularly nice, but some of the other courts may be not as nice. But in an arbitration, we basically just sit in a conference room, and you can see how nice the AIAC hearing rooms are. They're just like a conference room, just like a meeting room that you may have in your office. You talk about resolving disputes during COVID-19. You and I know that everybody's now onto webinars, onto virtual hearings. Everything is pretty much online as is now. And although this photograph here was taken during a webinar, you can see that in reality, a lot of the arbitration hearings nowadays will pretty much look like this, as opposed to being in the physical hearing room. Hearing attire, now that's a nice one. So on the far left, that's me getting called to the KL High Court in 1988. I know most of you are probably not born yet. And I was a court lawyer, so there was I in my robe and my bib and everything else. But when I went and started being active in arbitration, you'll notice, okay, this is quite a recent photograph of me in the middle. I was no longer wearing black and white. I was able to wear other colors, and it was really nice. But you want to talk about COVID-19 and resolving disputes? Have a look. That's me in my Zoom suit. Since you only have to look at the top part of anybody, I bet you all of us in our Zoom suits right now. In the way of proceedings for arbitration, it's not horribly different from the court proceedings in the sense of what are the various steps. I used to use this as an indicative schedule and a sample schedule just to explain to clients what are the various steps. You will notice here it's not terribly different to court, but you will also notice that from the time schedule, it may or may not be this way. For very complex matters, it may be much longer. In the case of AIAC's fast track rules, then you find that the timeframes are shorter and with a limit. So there are some compulsory timeframes. But the long and short of it all is that it's actually a lot more friendly. It's actually a lot less clumsy. And there's a lot of agreements between parties in order to just get things moving. Why do we say that arbitration is one of the best avenues to resolve disputes? There are many ways to resolve disputes. You and I can just talk over a data rate and that we can resolve our dispute. We can go to mediation, adjudication, what have you. Arbitration is favored because usually your arbitration clause has got a very, very wide coverage, and it will cover much more disputes than, for example, CIPA can. It's final and binding, and most of us are in arbitration-friendly environments where the challenges are limited, and even those challenges are not usually allowed to succeed. Importantly is the New York Convention, where there's basically reciprocal enforcement in the 163 contracting states. Now, you can't find that with a court judgment. So that's one of the important things. And of course, when I said to you earlier on, the flexibility of procedures, there's a lot of agreement between parties, and it's more friendly in that sense. So, young SCL, that's just a quick overview of arbitration. Happy to talk to you a lot more about it, but I leave you with whatever you do, be it arbitration, court, or whatever, be good at what you do. Be bold at the good that you do, and be good to others in all that you do. So I'll leave you for now and hand over.
Thank you very much, Swee Im. Now, most construction contracts I've come across, if not all, provides for arbitration as a final avenue to resolve disputes. So I think it is really important for students or young practitioners who plan to specialize in the construction industry to get accustomed to arbitration. Speaking of construction contracts, it is also common to see mediation as a condition precedent to arbitration. With the Singapore Mediation Convention coming into force in September this year, the mediation landscape will definitely see some big changes. With that said, I would like to invite to the E stage our next speaker to present on the topic of mediation. Dr. Christopher Toh is an independent mediator, adjudicator, and arbitrator who is on the panel of various leading global ADR bodies. He has arbitrated more than 100 international cases involving both ad hoc and institutional arbitrations, mediated and adjudicated many international and domestic cases. He is an accredited mediator, accredited adjudicator, chartered arbitrator, chartered engineer, chartered information technology professional, and a barrister at law. I thought I was going to lose my breath there. One of the many key positions he currently holds is the chairperson of the Hong Kong Institute of Directors. Christopher, the stage is yours.
Thank you very much, Awan. Okay, I'm going to talk about mediation overview. For those who know about mediation, I apologize. This is the general overview because I have a passion for mediation. Now, when people talk about dispute resolution, there's two ways of looking at it. One is, do you want to be more active in resolving your disputes, or do you want to be more passive? Passive means, if you look at it, for example, the screen on the left side, you see, for example, the avoidance. You try to avoid things. And all the way down, you see cooperative in terms of win-win. Now, mediation, what we're looking at is we're trying to be more cooperative. We're not trying to compromise. We're not trying to compete. We're trying to be more cooperative with each other to resolve our differences. Now, if you look on the screen on the right side, you see, for example, the various dispute resolution methods. Some of them are called non-binding, and ones are called binding. As mentioned earlier on, arbitration is a binding process, is a legal process. Mediation is a non-binding process. If you look at here, sometimes people use conciliation with mediation, in the sense that mediation is slightly different from conciliation, because in conciliation you tend to give advice, whereas in mediation you tend to adopt the facilitative mode. But in saying that, other jurisdictions have now gone into the evaluative mode, which I'll come on in a minute. Now, if you look at the time and cost, most business people are looking at the money side. How much is this going to cost me? So if you look at here, the chances are mediation is going to be much, much cheaper than other forms of dispute resolution. Doesn't mean arbitration is no good. Doesn't mean litigation is no good, because sometimes you want to take someone to court because you want to tell the whole world that if you create a problem, this is what will happen. Sometimes mediation works because you want to have an ongoing relationship. So you treat it this way. Mediation is one form of dispute resolution that you can use to actually handle your disputes. So if you want to save time and cost, you might want to try mediation. But if you want to give someone a lesson or tell them, for example, I'm right, you're wrong, then you might want to choose arbitration or even court litigation, as well as adjudication. Now, if you go down again, you see, for example, whenever you come to court or arbitration, you always assume, for example, your case is magic. Your case is wonderful. You're going to win. Okay, now the other side is going to do the same. So if the plaintiff and the defendant look at the point and they'll say to themselves, I've got a perfect case. So what do you think the judge or the arbitrator is going to do? Some's going to win and some's going to lose. So chances are you're not all going to be perfect. So that's why mediation comes in terms of assisting you to see whether you can actually cooperate so that both parties will not lose out. That's what we're trying to do. Now, if you look at mediation, the definition of it is one means of approaching conflict. Regardless of how it may be defined, mediation is only that one approach which may be more or less effective in facilitating the resolution of some conflicts with some people under some circumstances. This was done by Tillett. You can see that certain disputes, certain people, you can use mediation. But if people are very litigious and they're basically very hard-nosed about things, the chances that mediation might not work. So it has to be voluntary. People want to willingly participate in mediation. Now, the process, as I mentioned earlier on, some people use the facilitative mode, whereby the mediator facilitates people to communicate. Whereas other situations, people will say, Mr. Mediator, we want you to tell us who's right, who's wrong, or give us your opinion, so you evaluate. But sometimes when you evaluate, one party doesn't like it, and that could be issues about negligence, issues that come up as well. So the chances are you have to be very careful when you're drafting your terms and conditions as a mediator. You have to make sure, for example, there's no liability whatsoever. So that's why sometimes we tend to use the facilitative mode. Now, this is the standard model adopted in Australia, Malaysia, Singapore, Hong Kong, United States, and UK. So you can see there's a problem-defining stage and the problem-solving stage. You have the introduction, and all the way down, you go to the agreement. So you can see that there are basically 5 stages of mediation. You have an introduction process, you have a gathering information, develop options, build agreements, and close. So that's what we're trying to do. The whole process is trying to explore issues to resolve them in a more amicable way. Now, if you look at the AIAC standard form contract, especially clause 35, it does mention something about mediation. So you can see that I'm not going to go into the details of this, but it gives you some indication of basically AIAC is very active in this area. And you can see that more and more people, from my understanding, are using mediation. So if you look at the dates, from August the 15th, 2017, AIAC announced and published its suite of standard form contracts. So you can see that at the very bottom there, it says AIAC abandoned its previous approach, whether there's a separate contract for with or without quantities. So you can see that all the way through down, you can see that mediation, arbitration, and also sometimes litigation that helps parties resolve their differences. Now, the cornerstones of mediation, or sometimes people call it advantages or disadvantages, depends on how you say it, is confidentiality, because sometimes you do not want your dirty laundry to be aired in public. The key thing is, the problem is yours. You have to sit down and resolve it. You can't palm it on to someone else and ask them to resolve it. The mediator is neutral. He's impartial. He's not taking sides. Try to avoid assumptions, assuming things, okay? Try to be more realistic. What are the options? One example I always give people is, how can you sell snow to Eskimos? And most people say you can't sell snow to Eskimos because they have plenty of snow. So there must be other ways of doing it. The answer is yes, you sell them sculptures, ice sculptures and so forth. So that's a different way of doing it. Another thing that's very important is respect. You respect people. You don't assume they're wrong. Empathy and genuineness, open, honest, and last but not least, flexibility. And you can see that mediation, just like arbitration, is very flexible. Now, in a book, what makes a good mediator, okay? And this book called Brandon Peters, he said this, how to select the best mediator. He said, your success in mediation is directly tied to your choice of mediator. The 3 most important elements of selecting the right mediator for your case is the approach. As I mentioned, facilitative, evaluative, or therapeutic is different styles, okay? The style is he much more aggressive, much more laid back, or is he willing or she willing to work the parties to resolve the differences? Also the background. In certain cases involving medical negligence, I seldom touch those cases because I don't understand the terminology. I don't even understand what they really mean. So how am I going to assist parties to resolve the differences? So if you're familiar with that area, the chance that you can assist the parties to go one step further. Now, when you look at a mediator, okay, you can see, for example, this is the mediator on your right-hand side. He has to have an ego container, big feet, big bladder, and all that stuff. The answer is no. He's just like a human being. All he does is he's working within those 5 quadrants where Harvard University developed, called competing, collaborating, compromising, avoiding, and accommodating, whereby he will use all these skill sets to try to actually assist the parties to resolve their differences and also to generate options. Now, the role of the mediator is very important. As I mentioned, a few elements. One is the neutral, and also he facilitates the communication. He doesn't make a decision. That's very important on that point. Now, if you want to become a mediator, whether you're a gentleman or female, actually, I feel that female mediators are much more good at doing mediation than male. Sorry to say that, because my experience so far, I find that females are more sympathetic, more willing to listen. Sometimes male, like myself, tend to be very impatient sometimes. So the key thing is, these are the skill sets you need to have. And one very important thing that you must have, which sometimes lawyers don't have, is listening skills, okay? We only listen to the judge, but we do not really listen too carefully to our opponent because we always criticize them left, right, and center. So you have to have good listening skills. Very last but not least is the creativity. As I mentioned, how do you sell snow to Eskimos? The chance that you have to be creative. Now, one important thing, why mediation is becoming more popular now. Previously, mediation was a nice to have thing. Arbitration took precedence, but now mediation is coming onto the stream. If you look at this, this is what we call the Singapore Mediation Convention, okay, for short, okay, whereby quite a few countries now, I think there's over 50 odd countries have signed it, and they still have to rectify it. I think 3 countries have so far rectified it, whereby they will honor each other's mediation settlement agreement, provided it's done in an international setting. Like, for example, a party from Malaysia and a party from Singapore, and they do mediation and have a mediation settlement agreement, that will be resolved or enforced under the mediation, Singapore Mediation Convention, provided Malaysia rectifies it. Currently, only Singapore has rectified it. Hopefully, Malaysia will do that shortly, I think. Now, key thing about mediation, I always say, no one will make a difficult decision if there's any possible way to avoid it. Okay, that's business people. If you can avoid it, you might as well do it because you don't want to spend time and money. All Pacific disputes have to end sometime. You can't prolong it. You can avoid it, but eventually you have to come to some consensus in terms of moving forward. If I give you $5 more, you're not going to trust me. You're not going to say, why is he giving me, why, I'll accept that. You're going to say, why is he giving me $5 more? I just want $10 or 10 ringgit. Why is he giving me 5 more ringgit? There's something that I don't know about this, okay? So you can see, no settlements entered into without some doubt or some trust. Now, the whole thing about mediation is, try it, give it a go. And I think for young construction personnel, I think this is a good thing for you to actually develop your skills in, and because it's going to happen whether you like it or not. So, Awan, is that okay with you? Thank you, everyone, for listening.
There was 10 minutes on the dot. Thank you so much, Chris. Now, whilst mediation is often a condition precedent to arbitration, another point worth noting is that construction contracts often impose a bar for the referral of time and payment disputes to arbitration until after the contracts are terminated or after the works have been completed. As a consequence, contractors are forced to either finance their works up until the completion or to abandon their works altogether. Now, this brings us to our next speaker to discuss the final ADR topic on adjudication. Thayananthan Baskaran is a partner with Baskaran Kuala Lumpur and an associate member of Crown Office Chambers, London. Thaya's primary area of practice is construction law. He drafts various building and engineering contracts, advises on disputes arising from such contracts, and appears as counsel to resolve these disputes. Thaya also regularly sits as an adjudicator, arbitrator, and mediator. As we mentioned earlier, Thaya is the author of the book Arbitration in Malaysia, which is a really good book, and I implore you guys to buy it. Thaya was the chair of the Chartered Institute of Arbitrators Malaysia branch between 2017 to 2019. He was also the president of the Society of Construction Law Malaysia for the year 2016 to 2017. Now, Thaya, over to you.
Thank you very much, Iwawan. Good afternoon, everyone. I'm very happy to speak to all of you this afternoon on adjudication. You heard earlier from Swee and from Chris on arbitration and mediation, both of which are creatures of contract. So, you know, arbitration and mediation, as you heard from Chris and Swee, you know, both arbitration and mediation are creatures of contract. whereas adjudication is purely a creature of statute. It arises in Malaysia from the Construction Industry Payment and Adjudication Act. And the purpose of the SIPA Act, as it's popularly called, is to ensure timely and regular payment in the construction industry. And in order to ensure that, a system of dispute resolution was put in place, which has the force of statute. And this is a very quick process for resolving construction disputes in particular. Generally, it takes about 3 months from start to finish. And usually it only involves documents without any in-person hearing. So what I propose to do this afternoon, since this is a classroom series, is simply to give you all an overview of adjudication in Malaysia, particularly the 10 steps of adjudication. Yeah, so if I can first start with the first step. So the first step in an adjudication is the payment claim. This is a key document in the adjudication proceedings. Various basic and essential requirements for a payment claim are set out in Section 5 of the SIPA Act. So it must be in writing, it must state the amount claimed, the due date for payment, the cause of action, the works for which the amount is being claimed, and there must be a statement that it is being made under the SIPA Act. These requirements are essential, and the courts have repeatedly held now that if any of these requirements are not met in the payment claim, then the payment claim will be invalid and the adjudicator will not have jurisdiction in the matter. So these are very essential requirements that must be satisfied. This is also a very key document because it sets out the parameters for the course of action during the adjudication proceedings. So for example, if the payment claim is in relation to interim certificate number 28, then that will define the entire parameter of that adjudication. Next, the step 2 is the payment response. So this has to be filed 10 working days after the payment claim. It is strictly construed, the timeline, and if the parties are late, then the adjudicator is entitled to disregard the payment response that is late. The payment response must be in answer to the payment claim, so it cannot go beyond, in a sense, what's inside the payment claim. So if it's in relation to interim certificate number 28, then the payment response must be in answer to that. Though, of course, as a matter of defense, you can raise issues like deductions and set-offs and things like that. The courts are a little more lenient with payment responses as compared to payment claims. So even if an issue has not been raised in a payment response, now the position is that that issue can still be raised in the adjudication response. So that's step 2, and I move on to step 3. Step 3 is the notice of adjudication, which is also a very important stage in the adjudication proceedings. The timeline for this is 10 days after the filing, 10 working days after the filing of the payment response. The reason why the notice of adjudication is important is because it stops time from running for the purposes of limitation. It also marks the formal commencement of the adjudication proceedings. And insofar as our registration is concerned, it's after the notice of adjudication is filed that the party has to register the adjudication with the AIAC. The question as to the effect, if there is a delayed registration of the adjudication, what is the effect of it on the adjudication remains open because the courts have not decided that point yet, although it is presently being argued in court. Interestingly, the adjudication, the notice of adjudication can be filed by either party, so it does not have to be filed by the party who served the payment claim. It may also be filed by the party who served the payment response. So the party who serves the payment response, if he finds that the payment person who filed the payment claim hasn't filed it in, he may commence adjudication proceedings by filing a notice of adjudication. So that's step number 3, the notice of adjudication. I then go to step 4, which is with regards to the appointment of an adjudicator. So an adjudicator may be appointed either by agreement of the parties, or if the parties are unable to agree, then by appointment by the director of the AIAC. In order to be an adjudicator, a person must fulfill certain criteria. So they must have 7 years working experience. They must have a certificate in adjudication. They must not be a bankrupt, and they must not have been convicted of any criminal offense. A person, when they are appointed as an adjudicator, must also make a declaration that he or she will comply with the rules of natural justice, that there is no conflict, and that they will act independently and impartially. So that's step number 4, the appointment of an adjudicator. And then we go to step number 5, which is the adjudication claim, which has to be filed 10 working days after the notice of acceptance of appointment by an adjudicator. The adjudication claim is a little bit different in practice from a statement of claim in civil proceedings or a points of claim in arbitration proceedings, insofar as the adjudication claim is more in the nature of a points of claim in civil law jurisdictions. It's in the nature of a memorial that is comprehensive. So the claim, the facts in relation to the claim and the law in relation to the claim are set out in the adjudication claim, and all the relevant documents and authorities are then annexed to the adjudication claim. So it's a very comprehensive document. This is the usual practice in most adjudications I've been involved in. In some instances, parties leave out the legal authorities and leave that for a subsequent stage of submission, but the more modern practice is that everything is included, both the facts, the documents, as well as all the relevant legal authorities and arguments. Next, we have the security deposit, which has to be paid 14 days after the appointment of an adjudicator. Move on from that. And in response to the adjudication claim, you will have the adjudication response. Again, the adjudication response is in the form of a memorial. It is usually a very comprehensive document that includes the facts, the law, the relevant documents, as well as the relevant legal authorities. The time for filing of the adjudication response is 10 working days after the adjudication claim has been served. This again is a very strict timeline, and the courts have repeatedly held that if a respondent does not file the adjudication response within the 10 working days, then the adjudicator is entitled to disregard the adjudication response and to decide the dispute solely based on the adjudication claim. So in that instance where the adjudication response is filed late, the adjudicator is entitled to simply look at the adjudication claim, and there will be no breach of natural justice in those circumstances. I move on then to the adjudication reply. This has to be filed 5 working days after the adjudication response. It is optional, but in practice, it's almost always filed. I've not been involved in single adjudication where an adjudication reply was not filed. Again, the timeline is very strict, and if a party does not comply with this timeline, the adjudicator will be entitled to disregard the adjudication reply. I then move on to step 9, which is the adjudication decision. So the adjudication decision, various things have to be complied with by the adjudicator. The adjudication decision firstly must resolve and decide all the issues that have been raised in the adjudication proceedings. So all issues must be decided. That's number one. Number two, the adjudication decision must be in writing. Number three, the adjudication decision must be reasoned. So there must be sufficient reasons given for the adjudicator's decision on every issue that has been raised in the adjudication proceedings. Finally, the last two requirements, there must be a determination of the adjudicated amount, which is the amount the unsuccessful party is to pay the successful party, the time for the payment of that adjudicated amount, and the manner in which that adjudicated amount is to be paid. And finally, the fifth requirement is that cost must be determined. So costs in adjudication proceedings in Malaysia, it's compulsory that the loser pays the cost to the winner. So the quantum of the cost must be determined in the adjudication decision, as well as the time and manner for the payment of such costs. And finally, step number 10 is the timelines for an adjudication decision. So it's 45 working days from the adjudication response or the adjudication reply, whichever is later. In the very rare instances where there is no adjudication reply, then where there is no adjudication response, then it's 45 days from the day the adjudication response should have been filed. And finally, the parties are entitled to agree on the timeline for the filing of for the delivery of the adjudication decision. So in many instances where the parties have left out legal submissions from the adjudication claim, adjudication response and reply, those will come in later, and because the legal submissions are coming in later, very often the parties will agree that the time for the adjudication decision is extended to 45 working days after the final legal submissions come in. This timeline is also a very strict timeline. There has been a decision in the High Court in Kuala Lumpur where it has been decided that even if the adjudication decision is 1 day late, the adjudication decision will be invalid and will not be enforced. So that brings me to a conclusion as to the brief overview of adjudication proceedings, and I will take your questions later on in this session. Thank you.
Thank you so much, Taya, for unbelievably summing up construction adjudication within, 15 minutes. But to be fair, statutory adjudication in Malaysia is relatively new, so there's quite a bit to go through. If you would like to learn more about SIPA, we have an upcoming webinar on the 30th of this month, so do look out on our social media for the details. Now, evidently, all three ADR methods, arbitration, mediation, and adjudication, are attractive and practical, especially in the time of COVID-19 with social distancing rules and whatnot. But how do you go about managing these ADRs? To help me address this question, I would like to invite our fourth speaker, who will be giving an overview of AIAC's role in facilitating ADR. Now, the fourth speaker is Michelle Sunita Kummar. She is the Deputy Head of Legal at the Asian International Arbitration Centre. She is a Fellow of the AIAC UK and a Barrister at Law of England and Wales. She has also been called to the High Court of Malaya, the Supreme Court of Victoria, and is accordingly qualified to practice in the United Kingdom, Australia, and Malaysia. Michelle read law at Cardiff University and graduated with a first-class honours degree in law. Prior to joining AIAC, she was in legal practice at one of Malaysia's leading litigation firms. Now, without further ado, Michelle, the stage is yours.
Thank you, Iwawan. Thank you for that. So we've heard quite a bit about the AIAC. Swee Im, Chris, and Thaya have mentioned quite a bit about the AIAC. So I'm basically here to tell you what we do. We were formerly known as the Kuala Lumpur Regional Centre for Arbitration, or otherwise known as the KLRCA. Swee Im alluded to us also being known as the Regional Centre for Arbitration in Kuala Lumpur. We were established in 1978 by the Asian African Legal Consultative Organization, or otherwise known as ALCO, that was through a host country agreement with the government of Malaysia. Now, we were actually established in 1978 with the prime focus of being an arbitral institution, administering disputes in arbitration. Of course, since then, we've expanded our services into other forms of ADR, and that includes adjudication as covered by Attire, mediation by Chris, and domain name disputes, which hasn't been touched on at all. Dispute avoidance, which is, we've taken it in the form of the standard form contracts of the AIAC. So when we talk about arbitration, what are the various rules in which the AIAC is able to administer our disputes? It's through the AIAC arbitration rules, the AIAC fast track arbitration rules, and the arbitration rules. Where adjudication is concerned, we've got the AIAC adjudication rules and procedure, and this basically supplements the Construction Industry Payment and Adjudication Act 2012, as well as the CIPA regulations. With mediation, we've got the AIAC mediation rules, and as I mentioned, dispute avoidance, we've got the AIAC standard form contracts. I just want to touch very briefly on the variations to the arbitration rules. So the AIAC arbitration rules are the general form of the arbitration rules that we have. The AIAC fast track arbitration rules, on the other hand, are rules that are used primarily to enable parties to obtain an award in a more speedier fashion, whereas the arbitration rules is generally focused towards arbitrations or disputes which are premised on Sharia principles. On the left-hand side of my slide, you'll see our Bangunan Sulaiman. I think many of you would have had an opportunity to come to the Bangunan Sulaiman, where we occasionally have, well, actually not occasionally, we always have networking events at Bangunan Sulaiman. So these are basically the set or the suite of rules that we have. And as I mentioned, our primary offering is the administering of dispute resolution proceedings. So what does that really entail? So you've heard Swee Im talk about the commencement of arbitration. We've heard Attire talk about the registration of adjudication disputes via the Form 3. So the first task that the AIAC normally undertakes when we receive a case is the pre-registration review of documents. And that basically involves having to determine whether the particular case in question fits within the arbitration scope, whether certain preconditions have been satisfied before the case can actually be registered as an arbitration. Then, of course, we move on to the actual registration of the case itself through the AIAC suite of rules. We've got the appointment of neutrals by the director of the AIAC. And of course, when I talk about the appointment of neutrals, I'm talking about the appointment as an arbitrator, the appointment as an adjudicator, a mediator, a domain name resolution panelist, etc., so on and so forth. So then we move on to the collection of fees and disputes and deposits, sorry. So once an adjudicator or an arbitrator has been appointed, what normally takes place is the arbitrator or the adjudicator commences the proceedings. And once the proceedings have commenced, parties and the neutral appointed, whether it's an arbitrator or an adjudicator, agrees on the fees that are to be collected, whether in the case of an adjudication, whether it's the standard fees or the recommended fee schedule. And where arbitrations are concerned, parties can deviate from the typical schedule of fees under the arbitration rules, or they can adopt the proposed schedule of fees under our AIAC arbitration rules. So what we then do is we collect the fees and deposits because we act as a neutral platform or a fund holder in a sense. And we keep the fees and the deposits before it's then to the arbitrator or the adjudicator. Then thereafter, when the proceedings actually take place, what we do is we monitor the proceedings to ensure compliance to statutory provisions or tribunal issued directions. And this is where we actually play a more active role. We basically ensure that where a statement of claim is to be filed by a particular day, we send reminders to the adjudicator or the arbitrator that, look, this was your direction. In 3 days' time, the claimant is supposed to be filing in their statement of claim or their adjudication claim, as the case may be. One of the more important roles that the AIAC plays, especially where arbitrations are concerned, is the technical review of arbitration awards. And what that really involves is, prior to the tribunal publishing their award, they send us a draft of their award. And what that means is that when they send us a draft of their award, we undertake a technical review of that award. And really what we're supposed to do is to make sure that certain rules and provisions have been complied with where the award is concerned. And it's more of a technical specification so as to ensure that the award is as far as possible enforceable in any jurisdiction that is proposed to be enforced in. We've also got other ad hoc services that we offer. We've got fund holding arrangements. We've got tribunal secretaries. In fact, last year we saw our very first tribunal secretary appointment. And now with the COVID pandemic, we've branched into virtual solutions as well, holding virtual hearings and things like that. We've also got our room booking facilities in Bangunan Sulaiman, where we hold hearings, meetings, and we also offer operational and IT assistance. I should probably add here that we've recommenced our booking for facilities in Bangunan Sulaiman. So it's great to have that buzz again back in Bangunan Sulaiman, but they're very strict operating procedures that we've got to adhere to in view of the physical distancing measures that we've got to comply with. So another one of the things of our AIAC's role really is the capacity building initiatives that we take. So prior to the pandemic, of course, we've had all our evening talks, where we host our networking events, certificates, programs, and things like that. Now, of course, we've got our online webinars. So what is the AIAC looking like in a post-COVID-19 situation? So on my left, on the left of my slide, you will see the signs that you will now be seeing when you enter our Bangunan Sulaiman. I think it kind of makes me a little sad, to see admission with mask only. Unfortunately, that is the new norm, so to speak, and 1 meter away from each other. So, we've heard Thaya, Chris, and Swee talk about all our ADR offerings at the AIAC. And with COVID now in place, and with the economy now, taking a really bad hit, we actually anticipate an increase in the utility of ADR, specifically disputes arising from the construction industry. So we see a lot of construction disputes adopting SEPA and arbitration to resolve those types of disputes. The subject matter of those construction-related disputes, we anticipate arising from a disruption in supply chains, liquidity crisis, delay, reliance on force majeure clauses. These are things that we've already seen in the past, but we do anticipate a much higher increase in the utility of SEPA and arbitration as a result of the hit that the economy is now going to be taking. So, it's great that the Malaysian courts have now opened up themselves to conducting virtual hearings online, and that's, applauded. But what we do expect is a disproportionate increase in disputes, which may result in a backlog in litigation cases in court. So against that background, why would ADR be the most or the next best option? Arbitration, for example, we see it as a truly adaptive mechanism because ultimately arbitration gives parties the autonomy to determine how they want their proceedings to proceed. So it really and typically is catered according to parties' preference, whether they want a particular way in which the claim is to be served and things like that. So really arbitration, in my opinion, gives parties that power to determine how they want their proceedings to be conducted. SEPA, on the other hand, it's really a speedy interim resolution premised on the objective of overcoming cash flow problems. When SEPA was first enacted, it was really to overcome this conditional pay when paid clauses. So SEPA, as it stands already, it really does take up a huge chunk of the cases that we receive in AIAC, and we don't anticipate this to be slowing down anytime soon as well. mediation, of course, as Chris mentioned, really it's the preservation of relationships. All those values of empathy, understanding, you know, trying to understand where the other party is coming from as well. These are all, these values all go towards the preservation of relationships. And if you see my slide, I've hashtagged it Kita Jaga Kita, because ultimately I think when you look around in today's post-COVID situation, we're seeing a situation where, you know, we're not the only ones being hit as a result of the economic downturn. Your neighbor is being hit as a result of it. And really what you want to do is you just want to stand together with everyone and try to build the economy together. So in a way, mediation goes a long way towards establishing that, you know, trying to understand the problems that are being faced by the other party and trying to find a more cohesive, holistic resolution to the disputes that both parties are encountering. So really, that brings me to an end of my presentation. It's really very brief. All I just wanted to do was bring together everyone's presentation, you know, in terms of adjudication, mediation, and arbitration, how it gels with what the AIAC offers to construction industry as a whole. And with that, back to you, Iwawan. Thank you.
Thank you very much, Michelle. Looking at the picture of the AIAC building makes me miss it very much, especially attending the networking events at AIAC. That is where, in fact, as a young practitioner myself, I met most of the seasoned practitioners through networking events at AIAC. But anyway, before we begin the panel discussion, I would like to invite our final speaker to provide some comments on ADR from a client's perspective. Ronan Collins is a civil structural engineer who is currently serving as the head of project information management at Gamuda. Ronan is known for his work with the Irish Chambers of Commerce as well as the EU Chambers of Commerce. That's where I actually met him. In his spare time, Ronan is a humanitarian and is the current president of the Lighthouse Club, which is the Lighthouse Club KL, which is the Malaysian branch of the international construction industry charity aimed at providing financial and emotional assistance to those less well off within the construction industry. Now, without further ado, Ronan, over to you.
Thanks, Iwawan. Good afternoon, everybody. So, as you can see, I'm not a lawyer and it's not my field of expertise. So I've been brought onto this panel to keep a balance. And what I mean by that is when you talk about arbitration, mediation, or even litigation, they are and should be your last line of defense. And I will always argue that if you have got a dispute with your client, with your contractor, with your subcontractor, with your consultant, you need to sit down and try and resolve that one-to-one. That can be they're not performing, that can be they're not being paid, that can be they're not paying their subcontractors. There's any number of issues that are going on. But in my opinion, if you are going to rely on a contract and an arbitration clause in a contract, and you're going to go to that first, and you're not going to actually sit down and discuss the issues with the people that are involved, you're actually doing yourself a disfavor. As soon as you start moving towards any of these processes, you're inviting in third parties. And those third parties, like all the people in this panel, are professionals. They will look at the rules, they will look at the procedures, they will follow those, and they will adjudicate or mediate or arbitrate. And they will give you a decision. And that decision may or may not be what you want. So if you want to avoid a third party involvement, I would strongly urge that you sit down and air out your grievances and work out a plan to resolving it. And we now operate in a very, very strange time. None of us, even those who are more senior than me, have lived through anything like what we're going to live through in the next 18 months. And we're only at the beginning. So don't for 1 minute think that because the CMCO is in place, that we're about to get back to life as normal. There is no going back to life as normal. We now have construction projects which are going to be going a lot slower than we would like. We're going to have a lot of constraints around resources, both in terms of materials coming into the country, both in terms of labor, both in tax and access to labor. And everybody is going to be affected. You're not going to have the industry all of a sudden having one group doing great work and they're just plowing ahead and everybody else gets left behind. So whatever you think, you are now operating in a very, very different world. And going to the courts to try and get payment, going to the courts to try and resolve disputes, yes, you can, but beware, it's going to take you a long time because there's going to be such a backlog of those discussions, those arguments, those cases. So again, be aware of what's happening, be aware of the other person's constraints, be aware of the general constraints in the market, and start making sensible decisions, because in 18 months, 2 years, 3 years down the road, we work in a very small community and you're going to be working with the same people again. And if you've tried to put them in an awkward position, or you've tried to put them under, or you've tried to basically try and pull a fast one, they're not going to forget, and they won't come when you need them to come in the future. So this is a team sport. I get the importance of the rules. I get the importance of following the procedures. I get the importance of meeting the timetables. But I would urge you, before you start pulling the trigger, see if you can solve the problems before you go to just alternative dispute resolution. So thank you very much for inviting me on as an antagonist to the panel, and I look forward to the questions from the people who are attending.
Thank you very much, Ronan. Thank you very much once again to all of our panelists for sharing their insights on resolving construction disputes. We will now begin with our panel discussion, where we will also be taking up some of your questions. As we want to go through as many questions as possible, just a reminder to all of our panelists to try not spending too much time answering them. Now, the first question I have to the panel is this. Given the complexities and voluminous nature of construction disputes in general, would you say that not all types of construction disputes can be resolved remotely? Yes or no, and why in 30 seconds? Perhaps we can start with Swee Im.
Sorry, Iwawan, I actually lost you there for a moment, so I'm afraid I didn't actually hear the question. I think it's my internet connection.
Let me just repeat myself quickly.
Sure.
Given the complexities and voluminous nature of construction disputes in general, would you say that not all types of construction disputes can be resolved remotely? Yes or no, and why in 30 seconds?
Okay. Not all construction disputes can be resolved remotely. That is true. The reason is because, as you say, sometimes you need so many different types of documents being cross-referred, and that there is a certain sort of dynamic in terms of body language that one actually has to deal with as well. So you can go a long way, but I am not 100% convinced that you can go 100% of the way.
Thank you. Taya, do you have anything to add?
Yeah, I think it really depends on two things. One, the nature of the dispute, the particular construction dispute, and two, the nature of the dispute resolution proceedings itself. So insofar as the nature of the dispute is concerned, maybe a simpler standalone construction dispute, with one single variation that needs to be resolved, then doing it remotely is quite effective. Your whole final account dispute is going to be tricky. The second aspect, looking at the mode of dispute resolution, during the MCO, I found that the most effective was actually mediation. I had two major matters that were, mediated and resolved during the MCO period. I think given the uncertainties, people were also looking at settlements. Thanks.
Michelle, as a case counsel, what do you think of Swee Im and Taya's comment?
No, I completely agree, and I echo what they say. Just putting myself in the shoes of a case counsel, really, the amount of documents that we see come in, it's really voluminous. So I can only anticipate how difficult it must be to be cross-referring documents, and especially in a situation where you're having a hearing. More often than not, we see a lot of hearings being held in which you would like to have hot tubbing of experts and things like that. So I would anticipate that you'd have difficulties doing that on a virtual platform. And of course, you've also got instances where you need to have a site inspection. So I would echo what Taya and Swee Im says. I think it really depends on the nature of the disputes. I think it's probably more easier where you're talking about more SEPA type disputes, payment for work done. That's probably easier, where it's easier to do it based on documents alone. But really, it comes down to the nature of the dispute as well.
Chris, apart from the time and money claims that can be suitable to be dealt with remotely, what other kinds of construction disputes do you think can be resolved remotely, Chris?
I think certain issues about the law that can be dealt with remotely. But in terms of technical issues, so to give you an example, recently I was doing an arbitration with 3 arbitrators, and one of the experts was talking about couplings. And they went on such a degree that no one could understand what he was saying. So eventually we decided, why don't we just go to the site and have a look at what you're trying to tell us? So we went there, spent half an hour looking around, and we could understand what was happening. So in a way, sometimes site visits do help to understand or put things in perspective. So I think simple things like contract documentations,
legal issues and all that, that can be dealt remotely. But other things that are more complex, more technical, and if you have co-arbitrators who are not on the technical side, to actually go and visit the site would be much more preferable.
Interesting. We have a question from one of our participants. Would online hearing compromise the integrity and or outcome of legal proceedings? Does anyone want to answer this? Taya, perhaps? Taya, you're on mute.
I'll unmute myself. Yeah. So there's an interesting take on this, actually, Iwawan, which is that some people say the major thing that is compromised in an online hearing is you can't observe the demeanor of a person. But there's a counter take to that in a way, when, for example, they're looking at me now within this frame. And when you have someone within a frame, it's actually easier to determine their demeanor rather than when you're looking at them from across the table. And the other thing, with regards to bundles of documents, again, if you have electronic bundles that are presented on the screen, it may actually be more convenient than going through a physical bundle and thumbing through it and referring them to a particular page. So it has certain advantages. I don't really see it prejudicing any natural justice or things like that. Thank you.
Can I just add one thing as well, just for from a technology perspective? We're all sitting here doing web calls. There is no reason why this construction manager could not facilitate a visit to site using his iPhone and demonstrate to an arbitrator or a mediator a technical issue. They could do it live and take questions, or they could pre-record it. But the reason I say that from a construction management perspective, we are prohibiting visitors coming to our construction projects. And that would include people who don't necessarily have recent training, safety training, et cetera, et cetera. So while we would be more than happy to facilitate an arbitrator or mediator coming to visit us for a particular case, we will always look for a technological solution to that as well. So we now live in a world where most of our construction projects have got reasonably good access to technology, and we would look to leverage that as well. So not just having people traipsing around site, because at the moment, we want to try and minimize the number of people getting in and out of sites.
I'll just add to that as well, which is that as much as we are, as lawyers, are talking about online hearings, and this is, like a big step to go on to use technology for lawyers. What Ronan does, and in fact, I've known Ronan for over 20 years since when he was living in Hong Kong, the amount of technology that can be used by somebody who has skills such as Ronan's, and they are available out there as well, is that you can use technology so much more in actually assisting dispute resolution. The use of drones, the use of, even if you're not using BIM, if you're using sort of 3D technology. I remember Ronan used to use gaming technology to video and actually animate a problem so that it's much more understandable for everybody. And if actually the entire industry could use that and more of that, then I believe that all this online and all this IT stuff is actually going to be much more helpful. We're talking to young SCL, not all these gray hairs like people like myself. So actually, I would have thought that you all would be able to embrace technology a lot better than some of my generation. I look forward to it. So please come. When you are coming before me as and I'm your arbitrator, please give me those IT type of assistance. I look forward to it.
So yeah, just one last point on that. So the advantage of using a 3D game or a 3D animation is you can actually take apart a complicated issue and break it down into an easy to understand story. So we actually did a very serious case in Hong Kong about 12 years ago. It was involving a very serious formwork collapse in a very complicated system. Unfortunately, there was a number of fatalities in the incident. We're not allowed to show people what we did because of the way the case was closed. But the sequence of the animation, the detail of the video, the way it was done independently. So it wasn't done for one side, and it was done in such a way that a non-technical person could understand all of the steps and phases and issues, and the mechanism of failure was obvious. So and then they could debate who was responsible. But yeah, if you have a very complicated issue where a non-technical or an inexperienced arbitrator or mediator, then yes, there are technologies available that can help.
Thank you. On that note, Ronan, we've seen plenty of publications over the last few months talking about the dangers of COVID-19 to the construction industry. as well as the risk of disputes arising of the MCO, which is a lockdown in Malaysia. Now, having gone through the MCO period, what were or what are the actual challenges a construction company faced during the MCO? That's a question to you, Ronan.
This is not a past tense question. This is very pertinent and very relevant question as we speak. There are a number of issues. First and foremost, we want to make sure that we maintain the safety and health of all of our workforce. That includes the workers that are doing the work on site, the engineers that are managing them, and the people that are actually managing the actual projects. So health and safety comes to mind first. We are complying, and all of the construction projects that we're familiar with are complying with the government mandate that the workers have to be tested before they go back to work. That in itself is creating a bottleneck because there's just not enough tests available. So that's creating a slowing down of the industry in general. It's also a very, very expensive thing to do when you've got tens of thousands of workers that are being basically charged anywhere between 400 and 500 ringgit a test. That escalates to a very high cost very, very quickly. From our perspective, for Gamuda, we're also looking at doing other kinds of testing, which are more regular and more responsive. So we're setting up new testing regimes. So it's having a very, very interesting impact. It is something that we're doing professionally. It's something we're dealing with, as I say, on a daily basis. We've been lucky that we've been able to use some technology to speed up some of the checking and some of the health checks. But it is having a direct impact, and it will continue to have an impact on construction projects for the coming months. This is not something that's suddenly going to just evaporate and go away. We're going to be continuing to test workers. We're going to be continuing to monitor their health. And unfortunately, if there is an incident on the sites, we're going to have to take measures to isolate and contact trace and make sure we know exactly who's been affected by an infected person. So this is going to be a very serious issue for the industry for the foreseeable future.
Thank you very much, Ronan. If I could just quickly go around the table, virtual table, I must add, just quickly in like maybe less than 30 seconds, could you provide maybe 1 or 2 tips you have for construction players in this industry on how to manage the issues arising from the MCO or COVID-19? Maybe we start with Michelle.
Thanks, Iwawan. I think from just my experience of how things have progressed at the center, I think keeping proper documentation is so important. I think that's been a non-starter even before COVID-19. And I think I see that more, there's more importance and more significance is going to be placed on it simply because we're going to be doing hearings on a virtual platform. So there is a need to have your documents tight and together and all in place before you start your hearings or claims. So yeah, that would be my two cents worth.
Thaya, do you have, what's your comment on this?
Yeah, just briefly. Well, firstly, I think this topic has come up earlier as well, and I've seen it during the MCO. If it's possible to negotiate or mediate and resolve your dispute, given the current uncertainties, I think that is something that should be seriously explored, perhaps more than it used to be prior to this. And if you really can't, then as Michelle said, documents, be prepared before you go in. And once you're in, try to look at things more broadly, see if you can resolve your dispute on a documents-only basis under the fast-track rules or, in an adjudication, which is typically the case. And be open, to virtual hearings, to, presenting things by way of animation, as Ronan mentioned earlier. It is really a very effective way, a very effective medium of translating things from technical people to non-technical people. Thank you.
Thank you. Aside from that, Chris and Swee Im, is there anything else that you could add? Chris, you're on mute, Chris.
I agree with Roland in terms of negotiation. That's very important because we're seeing more than that. I do a lot of construction matters, and we're seeing more and more executives now sitting down, really putting their figures together and trying to get a compromise. And if that doesn't work, they try mediation. The last resort is arbitration litigation. One other thing I just want to mention is you have to be a bit careful because one attendee mentioned about, for example, meetup. I think if you want to talk about meetup, arbitration, mediation, arbitration, I think the key thing you have to look at is the Gao Haiyan and Kenai case in Hong Kong and understand the complications of meetup and how you can prevent it. So that will help that person.
Thank you.
So as the oldest in the group, this is the 4th recession that I am living through during my working life. And after 3 recessions and seeing that there is always a lot of problems and, people do go bankrupt, businesses do fail. But look at Malaysia and look at the world after every single recession. So I think that we must keep that big picture in mind, that there is actually a future at the end of the day and that problems can be resolved. But as everybody has said, problems must be resolved on the basis that you want to resolve the problems as a community. Because if I can spend 50 ringgit or 10 US dollars, I put that into the community, that same $10, 10 USD or that 50 ringgit is going round in that community. But if everybody chokes at cash flow, then the entire system basically gets choked and it fails. So I believe that in this particular case, we do need to be settling a lot more. We do need to be seeking compromise a lot more. Having said that, please, all of you are lawyers. Don't just go to and advise your clients, hey, I heard on the webinar, we must compromise. So we just put a figure on the table. No, I believe that you really must also know what your case is, because that is the basis of this compromise and these settlements and these discussions that everybody has been talking about. I don't care whether it's a kopitiam discussion or whether it's a full-blown arbitration. You must actually have something that is tangible, not just go there and bang table and say, I want so much, you got to save me. So it's a combination of everything, but most importantly, it's an understanding that this is a phrase I've been using, it's a very Malaysian phrase. You die, I die. So we're in this together, okay?
Really put. Thank you, Swee. Now, Singapore introduced a COVID-19 bill, which essentially gives temporary relief from some contractual obligations. Now, over the last couple of weeks, I'm sure you've seen plenty of articles and publications calling on the government to introduce a similar bill in Malaysia. If I could quickly ask Chris, what do you think of the Singapore bill? Do you think other jurisdictions should have one as well?
I think the Singapore bill is a start, okay? I think most people say we have to rely on the government to help us in terms of doing things. I believe, yes, the government can help, but at the end of the day, I think you have to help yourself to actually resolve some of the disputes. I think the bill does focus on construction and supply contracts all the way down to certain loans. And also it mentions, for example, things that directors must do and must not do and so forth. But at the end of the day, I think it is a start. It's not an end to the means to an end. And I think you have to actually look beyond that and see how you can actually compromise, as others have mentioned, in terms of compromise, in terms of, for example, your resources, what kind of resources you can wait and not use, and what resources you need to use now. And you have to make sure that your workers are looked after, because at the end of the day, those are the ones who generate income for your firm. So I think that's very important. So it's just a start. And I think it's not a sort of a fully comprehensive coverage, but it's just to kickstart the economy. And I think Singapore's done the right thing to do it.
Ronan, as a non-lawyer, what do you think?
I think Malaysia has to be very cautious. Singapore operates in what I would consider a very different manner to Malaysia. Singapore is very constricted. It's got a very compliant national ethos. Malaysia is far more liberal, far more a bit more closer to the Wild West than it is in Singapore. So any law that's brought in Malaysia would have to be very, very carefully considered, both in how it's enforced and how it actually would be applied. And I think we have a very different culture in our industry here than what you see in Singapore. So I've worked in Hong Kong. I've known Chris for many, many years. Hong Kong is closer to Singapore in that it's quite well organized and it's got quite what I would call a compliant population, and people follow the rules and play along. Malaysia is very diverse. It's geographically substantially bigger than either of those jurisdictions. And there's a huge variety of attitudes towards what are considered laws and contract clauses, et cetera, across the country. So I think Malaysia has to be careful that what might work in KL certainly may not work in other jurisdictions. So it has to be done carefully.
Thank you so much. Now, I think we've gone over 25 minutes past what we're supposed to finish, as expected. So I think we'll wrap it up with maybe one or two more questions. Now, the next question is for both Taya and Michelle. Naturally, time and money claims will be referred to adjudication, as you pointed out, Michelle, earlier. What were the challenges faced in adjudication during the MCO period? Perhaps, Michelle, perhaps you can address that first?
Yeah, sure.
From a case
Yeah, I mean, one of the biggest difficulties that we faced center with during the MCO period was the inability of us to register new cases. And that's really primarily because Section 38 of CIPA requires documents to be physically served unless the consent of parties have been obtained in advance. So if parties had obtained the consent to, say, serve their payment claim, their payment response by email, then that wouldn't have been a problem. But the problem really stems from the fact that Section 38 says that it requires personal service on the non-paying party or the unpaid party, as the case may be. So because the MCO was in place and with the temporary closure of the premises, we weren't able to accept registrations of cases. And that, of course, didn't affect ongoing adjudication proceedings because where the adjudicator and the parties in those cases had agreed to the use of email, that wasn't really so much of a problem. So adjudication proceedings proceeded as usual. But really, it was more of a difficulty for new cases that were being registered. So that was the primary difficulty. Of course, we also have, the untimely passing of our late director, Mr. Vinayak Pradhan, as well. But that really has been more of a problem where it came to appointments of neutrals. But that's something that's taken out of our hands. We really don't have any control over that. But we've done our best, and we hope that the industry understands that as well. So that's about it from me, Iwawan.
Thank you, Michelle. Taya?
Yeah, just taking off from where Michelle left off, I think that's right. I mean, in terms of registration, there was a difficulty that new adjudications couldn't be commenced because they couldn't be registered during the MCO because the Act requires it to be physically registered. Similarly, the Act requires for physical service of documents. So there was a problem with service as well, unless the parties agreed that it be served electronically. So that was a bit difficult. With regards to the adjudication response stage of it, the adjudication claim, presumably the claimant would have been ready because they went in, but the response, if the response was due during the MCO, then from my own experience, I saw it getting quite delayed because parties simply didn't have access to all the documents or were unable to take instructions. So that got very delayed. Of course, if everything was in, when the adjudicator was simply going through the documents and writing the decision, then the MCO was actually a perfect time to be doing that. If you had all your documents with you, then you could take your time and write a very well-reasoned decision during the over 50 days of MCO. And taking the court experience, we've seen many judgments being published in the middle of the MCO. Obviously, the judges were busy writing judgments as well. Thank you.
Thank you very much, Taya. Unfortunately, that is all the time we have left today with us. Two good key takeaways I've received from my fellow committee member, Lanya. Hi, Lanya, if you're watching. Now, firstly, notwithstanding the impact of COVID-19 from a litigious perspective, a major challenge construction companies face at the forefront is maintaining the health and safety of their workers, especially since there is limited testing for COVID-19 available to construction workers. Secondly, to focus on mutually resolving disputes amicably where appropriate to your matter, such as negotiation and mediation, before considering adjudication and arbitration. Now, before we conclude, I would just like to say a passing remark to all our participants, and I would like the speakers to give some words of wisdom, actually. So this is it. With the pay cuts and retrenchments going on, it is quite clear that the virus-induced recession is already here. Most of our viewers here today have not witnessed a recession in their lifetime and can't help but think, are we ever going to bounce back? And how long do we have to endure being out of jobs or living on a significantly lower salary? with the exception of Michelle, who probably has never gone through a recession as well, could I ask each of our speakers to give some words of wisdom to our young viewers to boost their morale? Can I begin with maybe Taya?
Well, I'm old enough to have gone through 2 recessions, the 98 and the 2008. And well, 98 was pretty bad. I just landed in KL, and the guy who picked me up from the airport was an engineer who had lost his job and was driving a car. So that was not a good thing. Yeah, I mean, there's light at the end of the tunnel. I suppose things improve. Of course, you know, in law, the work is generated, you know, in short term because of a slowdown as well. You know, you have a lot of construction, insolvency related disputes which are cropping up, bubbling up already, and then, you know, force majeure, frustration type disputes. So things are tough, but I think they are improving, and depending on your particular field, you may actually be quite busy. So that's it.
Ronan?
I'm not going to allude to how many times I've been in a troubling financial position, but I have been in a few dark holes over the years. For all of those who are listening, I would give you 2 nuggets of advice. First of all, it's a good chance to polish up on some new skills and try out some new ideas. So if you had something in the back of your mind, oh, I'd like to try that, or maybe I should have tried that, now is the time to do it. Because it will get busy, you will become busy in the future. So if there is something you wanted to try, whether it's not related to your work, it could be DIY, it could be gardening, it could be cooking, now is the time to sharpen those skills. So make time and do something that you learn a skill you want to do. More importantly, this is the time where even though you've taken a pay cut, or even if you've been furloughed and you don't have an income, you still have probably more than most. I would suggest that if you're on this call, you've got access to a phone and you've got access to the internet. And that gives you an advantage over most people. And my request from a humanitarian perspective is look out for the others. Look out for those who don't have the privilege. Look out for those who don't have access. It could be buying a bag of rice and giving it to security guards who are not getting fed or not getting looked after. It could be making sure your neighbors have got access to things because they're too terrified to go out. It could be something simple. But for God's sake, take Swee's advice and be good to others. And there is no amount of work, there's no amount of study, there's no amount of skills that will compensate from doing good. So be aware of what's going on around you, and be aware that you're more than likely in the 1% who are suffering from first world problems. And there's a lot of people in Malaysia who don't have the privileges you have. So please watch out for the ones that don't.
Thank you very much, Ronan, for reminding us, in fact, that we are indeed lucky. So we may not be happy with some job cuts or with the pay cuts that we're getting, but at least we've got more than some people do. So, and I would also recommend for all our viewers to actually look up Lighthouse Club KL. They've come up with a really, really good initiative called Caring is Sharing campaign, which is why our friend Ronan here has completely shaved his head. So it's a very good effort. So if you'd like to contribute to, you know, in humanitarian aspects, do visit Lighthouse Club's page, or I believe on LinkedIn. All the information will be on LinkedIn. Now, if I could move on to Christopher, what is your words of wisdom for our young viewers?
I think for young lawyers, I think the key thing is you have to learn about the technology. Most of you are taught contracts, and all that stuff, but you're not taught about BIM. You're not taught about, for example, smart contracts. You're not taught about anything to do with technology-related contracts whatsoever. So I think you need to learn more about these kind of areas, because construction, I've been in construction for some time, and I can tell you the business is not going to go out. It just goes down and it comes back up again. But when it comes back up again, at least you're prepared, as Roland says. You have to have the skill sets. And the skill set says you have to know what the industry wants. Modular construction, what is that about? How do you draft a contract so to cater for modular construction contract type of work? All those things that basically construction people know about, but lawyers sometimes find it difficult to learn. And I think this is the time to learn that. And last point is, very important is, I think we have to have faith in each other and try to actually work as a team to move things forward. Because most people in Hong Kong now are working as a team because of this incident. And previously, people were saying, I'm just worried about my own business. But now people are saying, let's work together. So you can see that disputes in terms of litigation have dropped, arbitration have dropped, but other forms of negotiation, mediation have increased. So you can see that that is happening in Hong Kong.
Thank you very much, Chris. Swee Im?
Recessions will come and go. So we actually have been thriving, not just as Malaysia, but as the world. So there's always that silver lining. The 1988 recession, in my case, drove me to construction. I was fed up of going to court every single day and making somebody bankrupt or selling off somebody's land. The 1997 financial crisis saw me take a 40% pay cut. And as a result of which, I founded my own law firm, which I ran for 20 years before I exited and became a full-time third-party neutral. Point is, you've got to be good at what you do and embrace it. I said to somebody once that even if you're a conveyancing lawyer and there's no conveyancing work, but there is litigation work in insolvency, do it. But don't just do it because you can't be bothered to do it and you've got nothing else to do. You do it because you have nothing else to do, but do it well. Put your back into it and put your passion into it, because if you do something well, you will get good at it. And there's always a silver lining, like I said. You're all highly qualified. You're lawyers. Think about everybody else who's so much worse off than you. So chin up and let's work at it together. We can do it.
Thank you very much, Swee Im. I always enjoy all these little chats with you. I'm glad you could share that with the rest of the audience, really. Last but certainly not least, Michelle, you've done incredibly well at a really young age. So what could you give our young viewers some words of wisdom as well?
I think, I would echo what Swee Im says. I've been very privileged to be given the opportunity to do what I love to do. Law has always been something that I was passionate about. And I'll take it as a compliment that you think I never went through any recessions. Well, in the 1998 recession, I was very young, but it also gave me my first view as to how things could get really bad. I was still, I must have been, 98, I was really young, but it still gave me an opportunity to see how things could get rock bottom. And I think, if I recall correctly, I think I accompanied my dad to a court case arising from a financial crisis, the Dana Harta Act and everything. So it gave me some insight as to how recessions work, the lows and then the highs that can come from it as well. So, just following from that, law was a passion from a young age. I love what I do. I loved litigation when I was in practice, and then I was given the opportunity to work at the AIAC, and I love what I do now as well. So I think the biggest takeaway for me right now is the fact that I'm very blessed to be doing what I'm doing now. I think all I want to do right now, taking away from what Ronan said, is to basically give back, to give a little to, young practitioners like yourself, what I've had the opportunity of experiencing as well. So, if I can share my passion, whether it's sports or, because of my experience in administering construction disputes, I'm happy to do that. So, yeah.
Thank you very much, Michelle. I do agree with that, which is why I'm quite happy that we've come up with the Young Society of Construction Law, where we have vibrant thinkers, community members who are constantly coming up with interesting events, such as the YSL Cares that Ronan was part of as well. So I agree with you. I do think the young practitioners, definitely they should come together, and there's always ways that you can contribute back. It doesn't mean just because you're young, you have nothing to contribute. That's absolutely not true. So I really don't think we have any more time. We've gone 40 minutes beyond. So thank you once again to our esteemed panelists for sharing your wisdom with us today. To all our participants, thank you so much for joining us, and I hope you found the discussion earlier insightful. We will be rolling out more webinars as part of our YSCL Classroom series in the next coming weeks. We hope to be working with some of the panelists here today, in fact. And as mentioned earlier, we have an upcoming webinar on the 30th of this month on the topic of construction adjudication. Now, if you would like to stay updated on our events and webinars, please follow us on social media. We are on LinkedIn, Facebook, and Instagram. Simply look up YSCLMY to follow us. Now, ladies and gentlemen, that concludes today's webinar. Thanks again once and have a very good weekend ahead. Bye-bye.